Go ahead.
All right. Hi, everyone. This is Joy Gossman. She's the Lake County Public Defender and has been since 2007. You should be able to read the little blurb bio of her. She was instrumental, I remember, when we started thinking about drug courts and mental health court. She was one of the instigators of the mental health court, and she still staffs the drug and mental health courts. And she is going to speak to us on questions number 7 and 10 of our consensus study, which is pretrial procedures and courtroom procedures and access. So whenever you're ready, Joy.
Okay, thank you. Again, I'm Joy Gossman. I'm the Lake County Public Defender. I actually started in the office in 1987 as an intern while I was in law school, and I just fell in love with criminal defense and specifically being a public defender. I was hooked immediately. I'm very drawn to the clients that I serve, and I'm very proud to be representing them. I think it's an important job. That everybody has quality counsel regardless of their ability to pay. And I think we have an outstanding office here in Lake County. I'm very proud to be the head of it. I could not be as proud of my office and have the resources that I have unless I had the support of our county board and our county administrator's office. And throughout the years, I've been fortunate to have that. So we have resources in our office that a lot of offices don't necessarily have. I've got 2 full-time social workers who work with our clients to find housing and treatment, provide therapy, clothing, food, whatever it is, whatever a social worker can do, my clients that can benefit from the social workers, they get a social worker. I also have an immigration analyst. Back in 2008, the U.S. Supreme Court said that criminal defense attorneys had to give advisals to defendants regarding immigration consequences of a conviction. And of course, we're all criminal defense attorneys. We're not immigration lawyers. And I was able to, with the help of the county, hire a person who actually does all those immigration investigations for us. And with the attorneys, they develop advisals to our clients, which is, again, very important. We have a large Hispanic population here in Lake County. A great number of our clients fall into the category of having potential immigration consequences. So we are able to help them navigate some of that, and that's really important. I think I'm going to start with question 10 first. It kind of makes sense to me to do that. So courtroom procedures and access. And I think one of the first things I want to talk about is how the public defender is appointed. And in Illinois, it's all statutory. Clearly, people have a constitutional right to an attorney. That's through the U.S. Constitution. Every state in their constitutions have, the right to counsel, and most of it is statutory. And in Illinois, it's statutory. So how the public defender is appointed depends on the size of the county. So in Cook County, it's over 1 million people. That's the only county that's over 1 million people. So the public defender is appointed by the county board president with consent of the board. If it's less than 1 million people, which is where Lake County falls into, the public defender is appointed by the circuit judges, which is how I became appointed. The circuit judges appointed me back in 2007, and I serve at their pleasure. And actually, that's how the statute is worded. So, I'm very proud that I got that appointment. I'm the first woman in Lake County to have that appointment, and I couldn't be happier about that. The creation of the public defender office is also statutory. So, if the county has a population of over 35,000 people, then there has to be a public defender office. A public defender will get appointed and there will be an office. Obviously, the size of the office, the number of staff is going to be dependent on the number of cases. So the smaller counties may only have 1 or 2 public defenders that are full-time. I have 33 lawyers in my office with a total staff of 47 or 48. If it's less than 35,000 in the population, then whether to have an actual physical public defender's office is discretionary for the county. So in some of the smaller counties, they may have public defenders that are under contract. It's only part-time work because they don't have a lot of cases. So, but again, that's all guided by the statute. They talk about, when I was reading about the current position, they were talking about the qualifications of the public defender. And the statute doesn't really talk about what the qualifications should be, except that we have to be a duly licensed attorney in the state of Illinois, which every attorney has to be if they want to practice law, and that we have to be properly qualified. So that could be very subjective. I will tell you that I know the public defenders throughout the state of Illinois. I know many of them personally, and all of them are highly qualified. They may have been in the office for many, many years. They may have practiced criminal defense for many years. And I think that they are highly qualified. I hope that people think that I'm qualified. Lake County has a history of appointing who I believe were very qualified public defenders. The public defender before me was David Brodsky. He's now a judge. And I think to be a public defender more subjectively is that you really have to have a passion for the work and a passion for helping the people in our community who may be at their lowest point. They're obviously indigent. Many of them have substance abuse and or mental health issues. And you really have got to want to help people, because so much of our job is not only the legal representation, but it's really handling their cases holistically. I think it's housing and food and clothing. You just have to have that mindset to want to help people more than just helping them in court. And I think most public defenders have that mindset. The public defender, once appointed, it is their statutory obligation to create an office and have personnel that are also, well qualified and well trained. And that's what we do here in Lake County. I painstakingly interview for prospective assistant public defenders and hire who I believe to be the most qualified. And, we do provide in-house training. We do training outside. We are constantly trying to teach about changes in the law, but also about skills and how to work with people and things like that. So I think we do a really good job at that. And as important as it is, I think, to appoint a qualified public defender to lead an office, to me, it's equally important that the public defender's office has adequate resources with which to represent people. Many offices don't have the resources I have. I'm very fortunate. I have an expert budget and whatever I need, I can, the county board is trying to support me in that. Many offices don't do that. So, to help other offices, or to find some kind of equity in how public defender offices are funded is to me is probably a more important issue than the qualifications of the public defender. Just my thoughts. Courtroom procedures and access, speedy trial. Speedy trial, we hear the term, but what does it really mean? It's constitutionally protected. You have a right to a speedy trial. And again, it's statutory in Illinois. If you're in custody awaiting trial, you are to be brought to trial within 120 days. That's by law. If you're out on bond or you're out of custody, you have to be brought to trial within 160 days. That's the law. Now, most cases can be handled in that time frame. A lot of the more serious cases cannot. And some of the reasons might, are continuances granted for good cause. And those could be, the reasons for the delay. There might be evidence issues, and I'm sure you've read or you've heard that there's a backlog sometimes with the state police in DNA testing or, evidence gathering. There might be witness issues. There might be fitness issues. Many of my clients sometimes are found unfit because they're not capable of understanding what's going on. Right now, COVID is playing a huge part. The Illinois Supreme Court has suspended all trials right now. And so we are going to have a backlog. So those 120 days and 160 days have been suspended. So, you know, a lot of things come into play. Sometimes I hear criticisms from people, not directed at me, but at the system, that they don't think that cases move fast enough. And sometimes the wheel of justice is slow. And I think we still have to have faith in it. You know, nobody likes to intentionally have someone sit in custody any longer awaiting trial, but we also don't want mistakes to be made because we're rushing, you know, cases to trial. Ultimately, it's the client who always decides whether to go to trial or not, and he could waive speedy trial. He could say, you know what, I'll wait a little bit longer because my lawyer needs more time, you know, to prepare the case or whatever. But again, it's statutory and constitutional. Some of the barriers to court access. Not exactly sure how to address this. I will say sometimes cases are not heard as timely as they could be, just because of court schedules. Sometimes it's just really busy, and you know, there's not a backup judge, or the judge who's hearing the case just has so many other cases on the docket that we may have to continue it. It could be the attorney's schedules. You know, maybe an attorney is going on vacation, so we can't have the hearing then, and you know, the judge is trying to accommodate. I will tell you that in my line of work with the criminal caseload, we work very closely with the courts and the state's attorneys to come to some kind of agreement with dates. That's not something we want to fight over if we can avoid it. And we do acknowledge that sometimes it's just going to take time. We try not to let that become chronic, that we can't get to a timely disposition of our cases. And I'm certainly stay on top of that in my office, but sometimes things happen and you know, we can't get to things as quickly as we'd like. Sometimes a space is an issue. When we were building the criminal courts tower, and you know, we didn't have courtrooms available. Sometimes they were under construction, or you know, other cases were being heard. You know, we just didn't have enough space in which to do what we wanted to do. We don't have that issue anymore now that the criminal courts tower has been finished and gave us 11 new courtrooms with build out capacity for 5 to 6 more. So for those of you who may not know, right across the street from my office, there's an 8-story building that has all the criminal courtrooms have been moved. Most of the criminal courtrooms have been moved to that building. And so that frees up the courtrooms in the older building for all the civil and family cases. So it does give us more space and more ability to move cases along, which I think is important. We still also have the branch courts for most of the minor traffic cases. So people don't have to drive into Waukegan. The officers don't have to drive into Waukegan. Branch courts are out in Mundelein and Park City and Round Lake. So that helps to move cases along. We're not crowding the courtrooms here in Waukegan. I will say that if somebody requires the assistance of the public defender and the public defender is appointed, my staff, do not go out to the branch courts. If you're in branch court and you're charged with a jailable offense and the judge appoints the public defender, say on a reckless driving case, that case will be brought to Waukegan. I just don't have enough staff to drive out to the branch courts. So those cases do come into Waukegan. When it comes to offering access to people with disabilities, the criminal courts tower was built ADA compliant. I was actually on a committee with other stakeholders on designing of the building and making sure that it met with Illinois Supreme Court standards and was ADA compliant. So if you were ever to go into the courtrooms in the new building, they're beautiful. Number one, they have windows, which I am a big fan of, but wider doorways. We have more speakers. So the judge has a microphone, the attorneys, everybody, so people in the audience in the courtroom could actually hear better, which we didn't necessarily have in the other courtrooms. For the hearing impaired, and I've had clients who are hearing impaired, especially, specifically I had a client in drug court who always required a headset that would amplify people talking in the courtroom, which helped tremendously. And every deputy in every courtroom has that. So if somebody were to come into court, even if it was just a spectator, and they, needed some help with that, the deputies have devices with which to help people so they could hear what's going on. Like I said, we have microphones for judges, witnesses, attorneys, and their speakers. There was an issue in bond court when the new tower opened up and we had bond court in 110. They had to build a temporary wall. Courtroom 110 wasn't built for bond court, and the other bond court was under renovation, so they moved bond court to 110 and they built a temporary wall there. And I know that there were people that were complaining, and rightfully so, that they could not hear what was going on in the courtroom, but the courtroom wasn't designed for that. They did make arrangements by, creating, putting up other speakers and stuff. I know Judge Winter addressed the issue very quickly, and it wasn't perfect, but it was certainly better than what it was. But anybody who comes into the courthouse and goes into a courtroom, should be able to hear, and if they can't, that should be able to be addressed. And I don't really hear many issues with it anymore. For the physical layout of the courtrooms, again, when we built the court tower, all the standards, were being followed. And it's interesting, we were actually mapping out, they made mock-up of the courtrooms in a building off-site that we went to and, walked around and made sure that we had enough room walking around tables, and that it met the requirements of the Illinois Supreme Court, whether it was the courtroom, the chambers, the seating available to the public. There's ramps, now, so for jurors. So if we have a juror that can't use the stairs to get to the jury box, there's ramps now. Same for the witnesses. And I know that that's been very beneficial to people. They also created attorney-client rooms outside the courtroom. So in the new building outside each courtroom are 2 attorney-client rooms, where before we didn't necessarily have that. In the old building, they had 1 or 2 rooms on each floor that we had to compete for. But now there's enough rooms where we could have confidential conversations with our clients before they go into the courtroom. And, it's got table, chairs, whatever we need, printer, because a lot of things get printed off. And that has helped a lot. We also, in creating the courtrooms, we created a room for the clients who are in custody. They can go into a booth and we would go on the other side, and with telephones, and we could see them, and there's glass between us. We didn't necessarily have that before. We had in the older courthouse, we would meet with our clients in the jury box and we'd be standing next to them and whispering, not necessarily as confidential as we would like it to have been. So, I think that the courts and the county, really went above and beyond in creating these courtrooms to make them workable for the people who actually use them. And I was very grateful that I was allowed to be a part of that team. And I think it helped a lot. Lactation rooms, they're required and they are available throughout the court buildings. And they're marked, there's maps now. They've actually enhanced the mapping of the layout of the building, so it's easier to find different rooms and stuff. But we do have lactation rooms. When I started in '87, boy, nowhere to be found. You were in a bathroom, I think. It just wasn't happening. But we have those now, and they do get used. Braille. We have Braille signs in the elevators outside every courtroom. Where all the wayfinding signs are and things. So I think we've enhanced what we have and made it easier for people. Interpreters are big, and we have interpreters in our office for clients who come and see me, but the courts provide interpreters for cases. So there's Spanish-speaking interpreters on staff with the courts. But we also use the language line a lot if it's somebody who speaks other than Spanish or English. And another thing that the county did, which I thought was really ingenious, they did a poll of county employees on campus of other languages that they spoke. And if we have a client who speaks a language, Polish was a big one. And, there's other county employees who speak Polish, they're willing to volunteer their time to come and help us out so we can speak with people and we don't have to continue the case in order to specifically get an interpreter if it's something, as simple as just trying to get another court date or things like that. We use sign interpreters. We hire sign interpreters to help us out in court also. I hope that this has enhanced people's access to the courts. I think we're always striving to make it easier for people. I wish maybe sometimes the campus was smaller. Sometimes I see people, struggling because they have to walk a ways from the north garage, maybe to the clerk's office and things. But, a lot of people are willing to help. There's wheelchairs available too for people who may need them. Elevators everywhere now. So, I hope that the experience has been enhanced for people. Public access is required. The courts have to be open to the public. The only caveat to that is in juvenile court, those matters are closed to the public except for very limited circumstances. So I encourage people to come to the courthouse all the time and just sit in a courtroom and watch what's going on. I encourage young people to do it if they want to learn about the court system, but it's open for everybody. Since COVID has hit, it's been a little challenging. The guidelines that have been put in place by our governor has limited our ability to actually go into courtrooms. So that's why we created Zoom access for clients. There's anywhere from 15 to 20 computer stations around the Waukegan complex for people to appear in court via Zoom. And there's assistance for them. So if they were to go to the law library and say they had to appear in courtroom 510 by Zoom, then they would go to the law library, they'd sit at one of the computer stations and they could log in, they get a specific login number. Our attorneys appear via Zoom, so everybody's appearing via Zoom. Sometimes that can be challenging, but having the assistance at the computer stations helps. I think one of the things that we learned during this was that not everybody has the technology with which to access Zoom court. So they had to appear, but they didn't have cell phones or smartphones with which to do that. And I think that there was a misperception that most people have a smartphone and that they can do that. And, I came back and said, listen, many of my clients don't have those resources. They don't have computers at home. The libraries were closed. They couldn't go to the library and try and access court. So the courts increasing the number of computers available to people has really helped. Also, the courts are live streaming court calls. You could go on the 19th Judicial Circuit's webpage every morning and every afternoon and click on some of the links to the courtrooms, and they live stream court now. So people still have public access, even though the courtrooms physically are closed, they can still see what's going on in court. Haven't been too many problems with that, not too much bombing. We've had a couple of the people taking over and doing not so nice things, but that's been limited now with the live streaming. So before I go on, I would be happy to answer any questions about court access, if anybody had any.
Yes, we have a few questions and I think you covered a few of them.
That's what I was just going to say. Yeah, she answered some.
Sharon is one of our question askers. Did you see some there that Ms. Gossman didn't cover there, Sharon?
On this topic, let's see. No, I think she covered most of them. I guess I have a question, which is, you say that this sort of access is required. I'm wondering, is it because Lake County is so fortunate in being able to afford all of these accommodations, or is this statewide?
It's, the Illinois Supreme Court has their courtroom standards.
Right.
I think a lot of it comes, my personal opinion, a lot of it comes down to resources. Does the
Right.
county have funds to update their courthouses? With us building out the new branch courts or this criminal courts tower, we had the resources with which to meet the standards that the Illinois Supreme Court and the ADA put into place. I'm guessing there are counties that aren't that fortunate, and once they probably do start renovations, they're going to have to meet those standards, but they may not be able to because of finances. That's what I would say. Lake County is very fortunate.
Okay. There's a question here.
You got it. Okay.
Okay. I'm just grabbing one. It says, Phyllis wants me to ask you about your security from angry or crazy people.
Everybody entering the administrative tower or the courtrooms, the court tower and branch courts, probation, they all have to go through a magnetometer. So, it's just like at the airport. I'll be honest with you, I think it's even more sensitive than what you get at the airport. My high heels go off all the time. And if you beep, you have to empty off all your pockets. You have to take off your belt, your jacket, everything like that. Even if you're an employee, you still have to do that. We don't get a free pass to walk in. And we go through the magnetometer. If we beep, they're winding you. So, I think it's very, very safe. When we say, crazy people, I say mentally ill people. Our officers now are CIT trained. Most of the deputies in the courthouse are CIT trained, and that's crisis intervention trained. And so more and more officers are being trained to de-escalate situations. I would say, and I'm talking pre-COVID, because COVID now, we just don't see what we used to see before with so many people coming into the courthouse. I think that there were a lot more issues maybe in the family courts than there were in the criminal courts. But even my staff are really good at de-escalating situations.
Mm-hmm.
In my office, my clients, a lot of them have mental health issues, but we've been trained on how to work with them and to try and keep them calm. And that don't get me wrong. I mean, there are people in courtrooms that, may blow up. They may, be very unhappy with what happened. I've been fortunate enough where I'm able, if it's my client, to talk them down and just, take them off to the side and talk to them and say, what, let's keep it calm. But I would say I'm not afraid to be in any of these buildings. I'm not afraid to be standing next to people. I think our buildings are very, very safe. And I think that employees in the county are trained to handle these matters. I don't really see an issue.
Okay.
Rosemary, do you want to take the next one, or you want me to, or what?
Well, I'll take one. I'll take Rose's. Rose Fader
Okay.
wanted to know what
Right.
percentage of people use public defenders.
Well, I handle anywhere from maybe 12 to 16,000 cases a year. I would say of the criminal cases, the adult criminal cases, about 2/3 of the cases are probably public defender cases. In juvenile case, the abuse neglect cases are almost 100% public defender cases. We are the guardian ad litem for the children who are neglected, abused and neglected, and we represent the majority of the parents. But you have to understand, a lot of these families come from poverty, so it doesn't surprise me that our numbers are that high. I would say the majority of people in the criminal justice system, the defendants, probably the majority are indigent. So we do get about 2/3 of those cases. Out of the delinquency cases, we're probably at 80 to 90% that we handle.
And how about raw numbers, since as a follow-up, since COVID, are you seeing more stresses on families and more cases?
In abuse neglect cases, we are seeing an increased number. And that is not surprising to us at all. We have seen fewer criminal charges and fewer criminal cases, Again, not surprising. And now coming into the winter, I think we're going to see even fewer cases. Where we did see, and I'm going to say it's anecdotally, an uptick is maybe in domestic violence cases and some DUI cases. But otherwise, you know, COVID has kind of kept everything in an even keel or even lessened the numbers, except in those categories I just talked about. But abuse, neglect, we have definitely seen an uptick in those cases.
Sharon, do you have another one?
Yeah, this is a question about homelessness. It says, homelessness is such a critical issue. How many of your clients who are homeless are you able to help? And maybe you can address any eviction issues too that you may be dealing with shortly, if not now.
We do not handle eviction cases. So
Okay.
by statute, we are very limited in the cases that we have. However, when people do contact us and they say, you know, before COVID, you know, I'm getting evicted, I need help, we refer them to other legal aid agencies that will do that. Like Prairie State handles evictions. And so we will, you know, refer people out. Homelessness is an issue here. Safe, affordable housing in Lake County is an issue. It's expensive to live in Lake County. And the places where maybe people could afford the rent may not be the safest places for them to be. And so it's constantly an issue. My social workers do a great job in trying to, you know, find safe, affordable housing for people. Very often it's a referral to PADS and going through their sign up and trying to help them with housing. I would say the most critical group is young men, because there's a hierarchy of who gets helped first. Like, and very often it's women and children. I get it. You know, obviously they need to find housing. So, you know, for men to get housing help, sometimes they end up low down on the list. But, you know, we do have organizations here and halfway houses and Oxford houses and stuff that we can make referrals to try and help with housing.
And there was a question about what is bond court? What happens in bond court?
So in bond court is where someone who's arrested, they have to see a judge within a certain period of time. It's usually 48 hours. And that's their first court appearance. And it's based on usually the seriousness of the offense. Some offenses, if the police charge you with an offense, if it's a misdemeanor like a minor theft or a minor traffic offense, they can just write you a citation and send you on the way. If it's a more serious offense like a felony or a domestic battery, DUIs typically, although those can be handled at the station, sometimes they come into bond court. A person has to see a judge within a certain period of time and the judge sets the bond. So bond court is the first appearance for somebody, and that's where the judge will ask them if, you know, they have an attorney or if they want the public defender to represent them. The law in Illinois just changed under the Bail Reform Act. People are entitled to an attorney at a bond hearing. So we were already staffing bond court 7 days a week, even though we weren't required to. Now we're required to, because we will get appointed. People are entitled to counsel at a bond hearing. It's a critical stage. You know, this is someone's liberty at stake. And so that's where the judge is going to hear some facts of the case. It's not to determine guilt or innocence. He just wants to, or he or she just wants to learn, you know, about the charges, and then make a determination as to whether this person should be released on a recognizance bond, which is just their signature and maybe some pretrial conditions, or if they should have a cash bond imposed and be remanded to the Lake County Jail until they're able to post cash. So that's what bond court is.
Okay.
How many?
To the next section then, unless there's something else.
I just wanted to ask her how many, what percentage of the people coming in are being required to give a cash bond?
I do not have those statistics, and actually I'm on a committee regarding pretrial practices, and we're trying to get a handle on that. Unfortunately, the county doesn't have a case management system at this time that can kind of pull up that information.
Yeah.
So unfortunately, we don't have that. Although the county is investing a lot of money in creating an updated case management system for the courts, the public defender, and the state's attorney's office, that should help us with that in the future. But I will tell you, like, as of today, there were 501 people in the Lake County Jail. So quite a few people have to post cash bond. A lot of people can post it. Some people can't, but as of today, we have 501 people in Lake County Jail.
Uh-huh. All right, we'll let you go on to the next topic. Thank you for
Sure.
taking these questions.
Sure. So the next was number 7, pretrial procedures. And so I'll just kind of go through in the order that the questions were and just kind of give the information that I have. And one was the bail bond system. And that's really a hot topic right now, not only in Illinois, but throughout the United States. And actually, Illinois, as of November 9th, has legislation pending in the Illinois Senate regarding eliminating cash bail. So as the law is now, the judge can impose a cash bond on somebody, like I said, and hold them in custody until they will post a cash bond to be released pending trial, or the judge can release someone on their own recognizance. Now, a couple of years ago in the Bail Reform Act, the Illinois Supreme Court was trying to encourage fewer people to be remanded, let them out awaiting pretrial. And so they put into the statute these category of offenses. And if it's a violent offense, if there's and certain misdemeanor offenses like DUIs and domestics and things like that, the judge still has the ability, or the judge can impose cash bond on any type of case. But those cases, you know, the judge still has 100% discretion regardless. Then they created this list of what's called category Bs. So that's a lot of the misdemeanor offenses and a lot of non-violent felony offenses where the presumption is that somebody would get a recognizance bond. They get just a signature bond unless some other criteria was met. So that did help to reduce the number of people that were getting remanded. It gets applied differently, perhaps by different judges based on their experience, and different counties. I mean, it's kind of all over the board. There's really not a lot of continuity as to how it's being applied, which can cause some problems, which is why we have this committee that we're working with now as part of the MacArthur grant that we received, where we're trying to address that and how we can change pretrial practices in Lake County to reduce the number of people in custody, you know, even more than we have already. So, you know, again, like today we have 501 people in custody. Most of those are awaiting trial. Some of them are serving a local jail sentence. A lot, I'm not going to say a lot. There are going to be people who are going to be remanded to the jail on a cash bond, not because of the nature of the offense, but because they have a history of failure to appear in court. They'll be released and they don't come back. And so then they have to have a warrant issued, get picked up on a warrant, and then they come back in front of the judge, and the judge is like, listen, I let you out and you don't come back, now you're going to sit in jail waiting your trial. They still set a cash bond amount, but if you're sitting in jail on a cash bond, it's because you really can't post bond. I don't know any of my clients that say, oh, I think I'm just going to sit in jail because I like it. Sometimes, historically, I've had people in the winter not want to post their cash bond because now they have a place to stay and they're getting fed. But typically, if you're in custody or waiting pretrial, it's because you can't afford to post your bond. So like I said, it could be the nature of the offense that keeps you in custody. It could be your history of failure to appear. One of the things that we're trying to address with this committee is why are people failing to appear? And it's for a variety of reasons. Very few people fail to appear in court intentionally. I just don't see that. A lot of it is they just forgot about their court date. They may have childcare issues. They don't have anybody to watch their children, so they can't come to court. They can't miss work. I mean, if your family is dependent upon you working, maybe you can't miss a day of work, or maybe your employer says, listen, if you miss today's work, you're not going to have your job anymore. Many people don't have transportation. It's not easy to get from the western end of the county to Waukegan. There's just not a lot of public transportation out there for that. And even paying money like for Uber and things, a lot of my clients can't afford to do that. So, we're trying to address that. I will tell you that in my office, through the MacArthur Foundation, we did get a grant to start a pilot program on text reminders to my clients, reminding them of their court dates. And interestingly enough, it's working. I guess that doesn't surprise me so much. It's the national average for failure to appear rate is about 10%. So about 10% of people don't come back to court. With our text reminder system, of the people who are receiving text reminders of their court dates, only about 4% are not coming back. So the text reminders are working. The challenge I have is I can't get enough people signed up for it. I have a lot of people refusing to sign up for it. One, many of them don't have a phone or haven't been able to pay their phone bill, so they don't have the resources with which to, maintain their phone and receive text reminders. And a lot of people are very distrustful of government having their phone number. Even though they have to give it as part of, a court case, they aren't comfortable giving out their phone number, which is okay. I don't force anybody to participate in this program. It's a pilot program. We're just kind of keeping stats. But we have found that text reminders is working. Studies across the United States have shown that text reminders are working. We all get text reminders for the dentist, the doctor, everything else. We might as well get it for court. So it's like, how can we implement that on a wider scale in order to reduce our failure to appear rate? And I think we're working towards that. And I'm very hopeful that that's really going to impact things. Let's see. Some of this you already have, but one of the things that we're working with our committee is, we're very cognizant of the fact as to pretrial incarceration, the negative impact it has on people. And many studies have shown that even 3 days in jail before you post bond, impacts your work, it impacts your family, it could impact your ability to maintain housing. So trying to shorten that period of time that somebody's in custody or put resources into place so they don't get remanded at all is very, very important. And like I said, that's not just Lake County, it's not Illinois, it's nationwide. People, I think, are starting to see how negatively it impacts people's lives. And we all have to remember, people are presumed innocent when they're charged with an offense. And so if they're sitting in jail waiting for trial, their liberty's been taken from them, and it could, they're presumed innocent. The Illinois Supreme Court has also created a commission to address pretrial practices. One of my supervisors in my office is on that commission, so he's constantly giving me the updates on what practices they want to put into place statewide in order to reduce the jail population. And, I think you had somebody from the sheriff's office speak to you before, but it's not cheap to keep somebody in jail. It's about $120 a day to incarcerate somebody in the Lake County jail. As a taxpayer, I'm not happy about that. If we can get people out of jail and get them to come back to court without reoffending, getting rearrested, I think it's not only better for the community, I think we can do it safely for the community, but I think it can reduce the cost to the taxpayers to maintain a jail that we may not need to have, so much space for, because we're not holding so many people pre-trial. It's interesting. Sometimes I'll have a case, it might be a retail theft, shoplifting case, and somebody's sitting in jail. They may have a history of failure to appear. But I said, we're spending more money keeping them in jail than the cost of the items that they're accused of allegedly taking. That's really not cost effective. I think we have to think of another way. So, going after or researching bail reform and coming up with alternatives, I think is really important, for the community to really get involved and say, we don't want to do this in our community. We want to do something different. When someone is able to post their cash bond, so people have to post, so say the judge sets like a $10,000 bond, they have to post 10%, which is $1,000, right? So to a lot of people, $1,000 doesn't sound like a lot of money. To my clients, $1,000, they may never have had $1,000 at one time, right? So say somebody's bond is $10,000 and they're able to post $1,000. They post that $1,000 with the courts through the clerk of the court, and they hold that money. So then they're released, and their case happens, whether it's a plea of guilty, whether they go to trial and it's found guilty or not guilty, or maybe the charges are dismissed. Even if the charges are dismissed or they're found not guilty at trial, the county keeps 10% of the money that was posted as bond. So if my client's bond was $10,000, they posted $1,000 to get out of jail, so the clerk is holding $1,000 of theirs. Even if they're found not guilty, the clerk keeps $100. So my clients don't even, people don't even get 100% of their bond back. In Cook County, they're trying to change that. I would like to see that change here. Now, the money that's being held by the county is being used to fund programs. I would argue that the criminal justice system should not be funded on the backs of the accused or people in the criminal justice system. I think we can find alternatives to programming, but even $100 that's withheld from somebody, for people like my clients who are indigent, $100 could be the world to them, right? That could be 2 weeks worth of groceries. That could be their electric bill. So I think that those are also issues that need to be addressed. That, bond be returned to people if they're found not guilty or if the charges are dismissed. But there have been arguments statewide and nationwide that if we don't have cash bail, that how are we going to fund the criminal justice system? And I think that argument has to be put to rest and say, we shouldn't fund the criminal justice system on the backs of the accused and bond. Any questions so far? That's a lot of information.
Somebody
sure.
asked to what degree does the court budget rely on the income from the cash bonds?
That I don't know what percentage of the court's budget. I will tell you that my budget, I know what my budget is. So I have about a $5 million budget for the public defender's office. For my services, defendants can be assessed a public defender fee. So I am not free. By statute, the courts can impose a public defender fee. The county only collects about $200,000 to $300,000 in public defender fees. I'm surprised they collect that much, honestly, because I represent indigent people. They don't have the money. And court costs are very, very expensive. So my budget is $5 million. My revenue is only about $200,000 to $300,000. So the county is paying for me to exist, but statutorily I have to exist. The court's budget, I am not sure how much of that is dependent on bond. That's a question you would definitely have to ask them.
And Sandra asked if she mentioned that Kane County has a CJ coordinating council, and I know you're on ours in Lake County. Mm-hmm. I guess she just wondered how that was working out.
So we did have specifically a criminal justice coordinating council, and it's kind of morphed into a sheriff's coordinating council. And right. So far we're meeting quarterly. And the sheriff's kind of running it right now. I think it's a great idea, and there's a lot of community members involved. We meet at night, so more people from the community can be a part of it. And we have an agenda. There's an agenda of items. But the sheriff's actually running that. I am a part of it. I'm on subcommittees. Like I said, we're addressing racial and ethnic disparity in the jail. We're addressing, pretrial practices and things like that. So I think it's pretty active.
Would you support no bond release for all?
I will tell you that I think a no cash bail is important. And I think it still gives the courts discretion to hold people charged with violent offenses. It gives the courts discretion to still hold people with a history of failure to appear. But I think it's also going to be a fairer way of treating people, again, who are charged with offenses, who are presumed innocent. And their liberty is not going to be dependent upon their income. And I think that that's very important. And, and we can always put safeguards in place. We really can. But I don't think people should be held in custody just because they can't afford bond. I just don't. I just don't. And I think that there's ways we can handle this without imposing cash bond on people. And still get compliant.
Holly Kerr, who you probably know, was asking, would the failure to appear be less if you could go to court via Zoom? That you didn't have to go there.
So I don't have statistics. I will tell you anecdotally, we are seeing probably a higher percentage of people appearing in court because they can appear via Zoom. We also, studies have shown across the United States, and I think even in Illinois and Cook County specifically, that without, even if you don't impose cash bond, the failure to appear rate and the rearrest rates really, they don't go up. I think it's this perception that if they don't have money on the table, that they're not going to come back to court. And that just, the studies haven't shown that. But we do have, I think, quite a few people being able to come to court because they can come via Zoom. So they don't have to take a whole day off of work. Maybe they can, change a lunch hour and appear at 9 o'clock as opposed to taking the whole day, driving in, sitting in court for hours and things like that. Then again, I think for some cases, I've heard the family law attorneys love it. And some of the civil cases. For criminal cases, when somebody's liberty is at stake, honestly, as their attorney, I want to be standing next to them and be with them. I just think that that's really important. But it's working. I know, for some types of cases, I think it's great. And I think that it will continue. I think for criminal, as soon as we can go back to being actually in court and being able to conduct our hearings and our trials and sentencings and motion work and stuff in person, the better.
Do you have some more questions to cover, Joy?
I do, just briefly.
Sure, go ahead.
Okay. We are working on one of the questions that you had here were risk assessments, and Illinois is looking at having a risk assessment tool that that will be statewide and will be less subjective. That was one of the complaints that I had with some of our assessments that were being used. Some of the questions that were being asked of people in a pretrial report, like how many times have you moved? Well, that could be very biased against people who don't have a lot of money, and maybe they do apartment hop or they get new apartments all the time. They're finding something cheaper. One of the questions was, how far did you get in school? And I'm thinking, well, you know what? Education can be a very sensitive topic, and there's a lot of bias in educational opportunities for people. Or unemployment. I don't think being unemployed necessarily means that you're not going to come to court. So we're looking at a public safety assessment tool. It's called the PSA. And, we're looking at implementing that in Lake County, and we're having meetings on that. And honestly, it doesn't even require them, the assessor, to actually talk to the client. The questions are just based on their record. It's what's the pending charges? Do they have prior misdemeanor convictions, prior felony convictions? Do they have a violent conviction in their past? Do they have a history of failures to appear? And based on those answers, which come from a record, they get a score, right? And then that score would be given to the judge and the attorneys, and we would create a matrix, and that score would tell us based on data that this person is a good risk to be released on their own reconnaissance. You know, they don't need a cash bond set. They don't need necessarily have pretrial supervision and all these other conditions placed upon them, or do they need that? And so I'm very excited about this tool. Clearly, the courts will always have the discretion to make the bond decisions, and they could always ask for more information. The attorneys could always provide information. You know, I could turn around to a client and ask them, do you have a stable place to live? Because it's important. I want my client to have a place to live. Do you have a way to come to court and things like that? But this tool is much more objective, I believe. And so that's one of the tools that we're looking to implement, and that the state of Illinois is looking to implement also. I think I covered that. The bail reform act, we talked about that. Electronic monitoring, I think that was one of your questions. So electronic monitoring of people, especially if it's pretrial where they're presumed innocent, can be very intrusive. And it's also very expensive. So, I've worked hard to allow my clients to get electronic home monitoring if it's available to them at reduced costs or no cost, because I'm like, my clients shouldn't be sitting in jail just because they can't afford, electronic home monitoring, and working with the sheriff's office and the courts, they've been very, very good about that. But again, when you're talking about people pretrial and they're presumed innocent, how many conditions do you want to place upon them if all we're looking to do is make sure that they don't reoffend and that they come back to court? So electronic monitoring, I think, has its place in some circumstances, not all. So, I think that's what I had. If anybody has any questions, or if I didn't cover something, I'd be happy to go back.
Okay, well, there was one Rose Fader wanted to know about the diversity within the staff of the public defenders.
That's an excellent question. I, like every public defender office that I speak to, we are challenged to hire people of color in the office. And it's something we work really hard at. I do have Hispanic attorneys, Hispanic staff, Indian, well, she just left the office to go to the state attorney's office, which is great. Would I like to have more? Absolutely. One of the challenges I have, and I've been working with the county on this, is the rate of pay of a public defender. And, the starting salary for a public defender is $58,000 and some change. I will tell you that in speaking with the placement offices at the law schools, they are telling me that, because I tell them, listen, I'm looking for applicants of color. I really want to diversify my office. And he's like, well, with your rate of pay, people of color can work at a private firm in the city for about 3 times what you're making. And I'm like, well, I don't blame them then, but it is an issue that I recognize. And it is something that I've been working with the county to try and rectify. And they've done compensation studies. They recognize the problem too. So we are working together to try and change that.
Okay, Sharon, do you see any other questions there?
No, I think we've covered them all from what I can see.
And Linda, anything else?
No, it looks like we answered everyone's questions.
All right, very good. Well, this has been just marvelous. Thank you so much, Joy. You've really covered things in a clear and understandable manner. And congratulations on being the first woman to hold the office of the public defender.
For a long time, too.
For a long time, yeah.
Yes.
Yeah.
But But I know that you've been in the public defender's office for a long time, and,
I have.
so you really have, it's evident your background and your devotion, and the special courts that we have in Lake
Yeah.
County. So thank you so much.
Oh,
And
you're
thank
very welcome.
Yes,
You're
thank
very
you
welcome.
very
Thank
much.
you for inviting me.
Oh, we really appreciate it. I'm going to put the closing slide back up and then hold that there for a little bit while everybody checks out. And we are going to post it on our YouTube channel. So we will send you the link. And we thank you. I was just really, I can't believe it was already an hour. It just went so fast. So thank you.
It went really fast. That's why I was looking at the time going, holy cow. Okay.
Rosemary,
Yeah.
what about, can we have any way of getting in touch with Joy if we wanted to, like
Oh, is
an
there?
email or
Yeah.
something like that?
Do you want me to put my email in the chat? I can tell you.
Sure.
It's the letter J and then my last name, Gossman at Lake County il.gov. So it's lakecountyil.gov. But I will also put it in the chat.
Oh, thank you so much.
And
Thank
I
you.
am happy to take any questions if anybody wants to email me. And if I can't answer the question, I will certainly find someone who can.
Thank you.
Well, I'm going to stop the recording, but we will still be here in 3, 2, 1. Stop. And